The flat is empty. Your boxes are in the car, and the carpet has those pale rectangles where the sofa stood for 2 years. The letting agent is walking through the rooms with a phone in one hand, photographing things. They stop in the second bedroom, where there is a scuff on the wall about the size of a hand. And they say it without any drama at all, the way you would mention the weather. Don't worry about that. The deposit covers it. 5 words said kindly. And if you go along with them, you have started giving away money you did not have to give away. Because that sentence only sounds like reassurance, when what it actually does is announce a decision that the person saying it cannot make on their own. Your deposit does not belong to the agency, and it does not belong to your landlord. It is your money, held under a scheme set up by an act of parliament. And broadly, there are 2 ways any of it lawfully ends up with your landlord. Either you agree to it, or somebody independent decides. An adjudicator at the deposit scheme or a court. Agree in that hallway, and you have handed over the first one. So I want to give you 4 things. 1 sentence to say at that moment, the reason the law puts the agent under pressure the second you say it, the trap that cost people the rest of their deposit after they thought they were being reasonable, and a check on your phone tonight that most renters have never done. First, the boundary, and I am going to be strict about it. This is England. Only England. This spring, the law here changed in a way that has not happened in nearly 40 years, and it changed for England. Wales has run its own system since 2022, with occupation contracts under the Renting Homes Wales Act, and different words for almost everything. Scotland and Northern Ireland are separate again, with their own schemes and their own deadlines. If you're not renting in England, the shape of this will look familiar, but the details underneath it are not yours, and that is worth knowing in the first minute rather than the last one. This is legal education, not legal advice. I am not a solicitor, and I am not yours. Now, what actually happened in May, because it decides whether the rest of this applies to you. Section 2 of the Renters' Rights Act 2025 is titled, as bluntly as it sounds, Abolition of Assured Shorthold Tenancies. The commencement regulations that switched it on are Statutory Instrument 2026-421, made on the 16th of April and brought into force on the 1st of May. What that means in your kitchen is this. Most private renters in England used to have an assured shorthold tenancy. On the 1st of May, most of those became assured tenancies. Same flat, same landlord, same rent, different legal name. And the deposit rules moved with them. Chapter 4 of the Housing Act 2004 is the deposit law, and every place it used to say shorthold, it now says assured. So the protection did not shrink when the name changed. It followed you. This matters for a practical reason. A lot of the advice online still says assured shorthold, and it was written for a world that ended in May. If somebody tells you the deposit rules do not apply to you anymore because your tenancy is not a shorthold, that person has read the news headline and not the amendment. Right, the 2 duties and the clock on both of them. Section 213, subsection 3 of the Housing Act 2004, where a landlord receives a tenancy deposit, the initial requirements of an authorized scheme must be complied with within the period of 30 days, beginning with the date on which it is received. 30 days to get your deposit properly protected under one of the schemes. I am being careful with that wording because it matters later. The duty is to comply with the scheme's initial requirements, which is not always the same as physically paying your money in. In a custodial scheme, the money does go to the scheme. In an insurance scheme, your landlord keeps it and insures it, and they have still complied. Then subsection 5 and subsection 6. They must also give you information about that scheme in the prescribed form and, quote, within the period of 30 days beginning with the date on which the deposit is received by the landlord. 30 days again for a separate duty. 2 duties, 2 clocks, both 30 days. And people miss the second one constantly, including landlords, which is the entire point of the check I will give you later. There are 3 schemes in England, and they are the only 3. The Deposit Protection Service, the Tenancy Deposit Scheme, and My Deposits. Stop on the custodial and insurance distinction for a second, because it changes what is happening in that empty flat. If your deposit is custodial, the agent standing in front of you does not have your money at all. They cannot take anything out of it. They can ask the scheme to release it, but the scheme will not simply hand it over on their say-so. The other side has to agree. And where there is no agreement, it goes to the scheme's dispute service. So when they say the deposit covers it, in a custodial scheme, they are not describing something they can go and do. They are asking for your agreement in a voice that does not sound like asking. Now the rule underneath all of it. Deductions have to be reasonable and they have to relate to money the landlord has actually lost. It has to be a real loss rather than money they might spend or an improvement they would like, which is why the second half of that rule catches so many claims. You have to return the property in a similar state to how you found it. You do not have to hand it back better. If the carpet was 5 years old when you moved in, and it is now 7 years old, that is 2 years of ordinary life, not damage, and you do not owe anyone a new carpet. And fair wear and tear cannot be deducted at all. Small scuffs on walls, faded curtains, worn flooring, those are the effects of somebody living in a home, which is what the landlord was being paid for. The schemes apply that sensibly. They look at how long you lived there and how many of you there were. A family with children leaving after 5 years is allowed to have worn the place more than one person leaving after 6 months. And follow the loss rule all the way through because it changes the size of a claim as often as it cancels one. Say you genuinely did ruin the carpet in the living room. You spilled something, it will not come out, and nobody is pretending otherwise. The invoice for a new carpet is £900. That invoice is not the number. Think about what your landlord actually had the day before you spilled anything. A carpet already partway through its life, which you were entitled to go on wearing down anyway. Buy them a new one, and they end up better off than they started. And improving the landlord is not something your deposit is for. What they have actually lost is the life that carpet had left in it. So when a claim arrives, quoting the full cost of a new item, the question is not only did I damage this, it is also how old was it and how much of its life was left. That second question is often worth more to you than arguing about whether the mark was there when you moved in. So the scuff in the second bedroom is not automatically anything. It is a question, and the answer depends on evidence, and it is not the agent's answer to give. Which brings us to what to say. The moment you are in is a moment where somebody is trying to close a decision. Everything depends on you not closing it without being the person who argues in an empty flat about a scuff. So here's the sentence. I'm not agreeing to any deduction today. Then a pause and the rest of it. Please put the amount and the reason in writing with the check-in and check-out reports and the evidence for what the landlord has actually lost. Return the part you're not disputing now. And if we can't agree, I'll ask the scheme to decide. Say it once evenly and then stop talking. Now look at what each piece of that is doing, because there are no magic words in it, and every clause is there for a reason. I'm not agreeing to any deduction today. That closes the only door that costs you the money. Remember the two lawful routes, your agreement or an independent decision. Agreement is the one available in that room, and this removes it. You have not refused anything. You have not called anyone a liar. You have declined to decide standing up in a hallway with your car double parked. Put the amount and the reason in writing. A number and a reason are much harder to invent on paper than in conversation. And the moment it is written down, it can be compared against the check-in report, with the check-in and check-out reports and the evidence of the loss. This is the part that quietly wins it, and I will come back to it in a moment. Note that I said evidence, not receipts. A landlord does not always have to have paid the bill already, and a reasonable quote or estimate can support a claim. What they cannot do is name a figure and leave it at that. Return the part you're not disputing now. Almost nobody says this. If they want £200 out of a £1,200 deposit, there is no argument about the other 1,000, and no reason for the other 1,000 to sit in the middle of a dispute it has nothing to do with. And if we can't agree, I'll ask the scheme to decide. Not a threat. A fact about a service that already exists, that all three schemes must provide, that costs you nothing, and that they know goes to somebody who is not them. Which takes us to the evidence, because this is where deposit disputes are actually won and lost, and it is not where people think. If a landlord wants to keep money for damage or cleaning, they need to show what the property was like at the start and what it was like at the end. The inventory and the check-in report at one end, the checkout report at the other. Schemes treat those as the good evidence, and where a landlord does not have them, they are likely to reject the claim. That is where the whole balance of this sits. The landlord is the one who has to make the deduction stand up, rather than you having to disprove it. That is not a courtroom rule about burden of proof, and it does not mean you can sit back and send nothing. You should still put your own evidence in, and I am about to tell you how. But it does mean that a written claim with no check-in report attached tends to quietly shrink. So on the day you move out, before you hand the keys over, walk the property with your phone recording. Keep it short and factual. Say the date out loud. Film the meters. If something was already broken when you arrived, say so while you were filming it. If a scuff is 2 years of a hallway being a hallway, say how long you lived there. That video cost you a few minutes on the day, and it is one of the most useful pieces of evidence you can hand a scheme, alongside your check-in report and your photographs. And if you can, be there for the checkout inspection and walk around with them. If they write down something you disagree with, say so at the time and make sure your disagreement is recorded. You cannot be charged a fee for an inspection or an inventory either. Here is the worry that stops careful people doing the sensible thing. Suppose they come back and say they're keeping 250 pounds and here is the rest. And you think, fine, I will take the rest and argue about the 250 later. And a small voice says, if I accept this money, have I accepted the deduction? You have not. Getting part of your deposit back does not mean you have agreed that they can keep the rest. You can take what they have returned and still challenge what they have not. So take the undisputed money. It is yours. It is not a settlement. And there is no reason to leave 1,000 pounds parked in an argument about 250. Next, the things they cannot charge you for at all, whatever your tenancy agreement says. The tenant fees. Act 2019 sets out a closed list of the payments a landlord or agent is allowed to require. Anything outside that list is a prohibited payment. The list is rent, the tenancy deposit, a holding deposit, certain default payments, payments for varying or ending a tenancy at your request, council tax, utilities, a television license, and communication services. Cleaning is not on that list. The word does not appear in it. So a clause saying you must pay for a professional clean at the end of your tenancy regardless of the state you leave the place in is not something they can enforce. And the same goes for admin fees, inventory fees, checkout fees, and a renewal fee for the privilege of staying. Hold on to that qualification because this is where people overreach and lose credibility in a dispute. None of that means cleaning can never be deducted. If the check-in report shows the oven clean and the checkout report shows it filthy, that is a real loss. And a reasonable cost of putting it right can come out of the deposit. What the Act kills is the unconditional clause, not the evidenced loss. Default charges are narrow too. Only 2 things count: losing a key or a security device capped at the costs, actually and reasonably incurred, and supported by written evidence given to you. And rent more than 14 days late, where the charge cannot exceed an annual rate of 3% above the Bank of England base rate, worked out day by day on what is still owed. Anything beyond those 2 is prohibited, and the deposit itself has a ceiling. 5 weeks' rent where the annual rent is under £50,000, 6 weeks' rent at £50,000 or above, with a week's rent defined as the annual rent divided by 52. Watch the labels here. Any extra refundable sum taken as security for your obligations under the tenancy is part of your tenancy deposit, whatever it gets, called on the paperwork. So a pet deposit counts inside the 5 weeks rather than sitting outside it. One thing that is not a deposit at all, and it catches people who thought they were saving money at the start. You may have been offered a no deposit or zero deposit option. Instead of handing over 5 weeks' rent, you pay a smaller non-refundable fee to a company. Plenty of people choose it, usually because finding 5 weeks' rent while also paying rent somewhere else is genuinely hard. But be clear what you bought. That fee is not a tenancy deposit. Your landlord does not have to protect it in a scheme. None of what I have said about the 30-day duties applies to it, and you do not get it back at the end. These products vary, and you have to read the actual terms, but the pattern is that the protection being purchased protects the landlord, not you. If there is damage at the end, you can still be pursued for it, and you cannot be forced into one. If a letting agent presents it as the only way you are getting the flat, that is a sales position, not a rule. Something else worth knowing before the end of a tenancy. If the agency has changed or the landlord has sold up, your deposit does not evaporate in the handover. Your landlord stays responsible for returning it, and that stays true even if the old agent never passed the money on. Whatever went wrong between them is between them. Now the check I promised, and it is a short one. Go and confirm two things. One, that your deposit was actually registered with one of the three schemes within 30 days of you paying it. Each scheme has its own lookup on its own website, and each asks for a slightly different combination of details, so use whichever ones that scheme asks you for. Two, that you were given the prescribed information within 30 days. And know what that second one really is, because most people have never looked at it properly. Most of us picture a friendly email saying your deposit is protected. What the law actually demands is a defined list: the scheme's contact details, the scheme's leaflet, how the deposit gets repaid at the end, what happens if one of you cannot be contacted, what happens if you disagree about the amount, the facilities for resolving a dispute without going to court, the amount, the address, the names and contact details of everyone involved, the circumstances in which the landlord may keep any of it, and, right at the end, a certificate signed by the landlord confirming that all of it is accurate and that you were offered the chance to sign it too. A signed certificate. Go and see whether you ever got one. Because if either of those 30-day duties was missed, Section 214 of the Housing Act 2004 may support an application to the county court. And subsection 4 is unusually strong for a tenant. Where the court is satisfied the duty was not complied with, the court must order the landlord to pay you a sum of money not less than the amount of the deposit and not more than 3 times the amount of the deposit within 14 days. Must rather than may. The amount inside that band is for the judge. And the piece almost nobody knows. Subsection 1A says the application also works where the tenancy has ended, and the reference to the tenant is then to the person who was the tenant. So moving out did not close this. If you left a flat in England where the deposit was never protected, or where you never got that signed certificate, that did not expire the moment you handed the keys back. Now, the honest version of what that is worth, because I am not going to sell you a payday. Whether you have a claim at all depends on the facts and the dates. What the court orders about the deposit itself depends on whether the tenancy has ended and whether the money has already come back. And the figure inside the 1 to 3 band is the judge's to choose. A missed deadline is a reason to get advice. It is not a guaranteed check. Practically, the claim is a Part 8 claim form, the N208. It currently costs £387 to issue. You can ask for interest. You can ask for that fee back from the landlord, and you do not need a solicitor to bring it. You should send a letter before action first, setting out the claim, and some landlords do settle at that point rather than take on the costs of defending it. Do not sit on it, though. Time limits exist for this kind of claim, and I am not going to put a number on yours because that depends on your dates. Ask an advisor early rather than late. Now the honest limits, because I would rather you were harder to sell to. None of this means a deposit can never be reduced. If you broke something, you broke it, and a reasonable cost of repairing it can come out. The rules do not make you immune. They make the process fair. And going into a dispute claiming a landlord can never deduct anything is the fastest way to lose the parts of your claim that were actually good. Scheme adjudication is a decision on documents. Nobody visits the flat. It is decided on the reports, the photographs, the receipts, and the letters, which is a huge advantage to whoever prepared. And that is exactly why the 4-minute video on move-out day matters more than being right. And the penalty claim depends on facts you can prove. If the deposit was protected on day 9 and the paperwork landed on day 20, both duties were met inside 30 days, so those dates alone would not give you a 30-day breach to argue about. A demand letter built on one will simply make you look like someone who found a video on the internet. Finally, the line not to cross, and it is the most common mistake in this whole subject. Do not stop paying the last month's rent and tell them to take it out of the deposit. I understand exactly why people do it. You are worried you will never see the money, so you hold the one thing you still control. But the deposit is security, it is not a rent payment, and deciding it is one does not make it one. What you have created is rent arrears. And arrears are not a small thing now. Under the Renters' Rights Act, the mandatory rent arrears ground was made harder for landlords to use, moving from 8 weeks to 13 weeks where rent is weekly, and from 2 months to 3 months where it is monthly. Harder, but still there and still mandatory once its conditions are met. You would be building your landlord a case in exchange for money you already had a legal route to recover. So pay the rent, use the sentence, and let the scheme do the deciding. So the whole thing in order. You agree to nothing while you are standing in the flat, and the sentence goes out once. Before you hand the keys over, you walk the property filming, with the date said out loud and the meters on camera. When the written claim arrives, you compare it line by line against the check-in report, and you ask for the evidence behind every figure. You take back the part nobody is arguing about. If you cannot agree, you go to the scheme's free dispute service with the video, the 2 reports, and the emails. And separately from all of that, tonight, you check the 2 30-day dates. If you need help, it is free, and you should not pay anyone for it. Shelter's housing advice is free. Citizens' advice is free. Every one of the 3 schemes runs a dispute service that is free to use, and their numbers are on their own websites. Learn it now, while your flat is still full of your things and nobody is standing in it with a clipboard. Subscribe, so you know the sentence before you need it. And if there is real money in this for you, take it to someone qualified. This has been general information about how the law works in England, not advice about your situation. For that, speak to a qualified solicitor.